Good evening, everybody. Tonight, we're going to start, it's a little bit after 7, but we do have our supervisors meeting following directly thereafter. I'm assuming that we have to put it on the record that we are under video tonight? Okay, so we are under video tonight. Recording devices will be used during this meeting. Tonight, it's the Rouse Chamberlin conditional use application for 1163 Horseshoe Pike. For the applicant is seeking conditional use approval pursuant to section 399/39.b, section 6, and standards set forth in section 399.41.b in the East Brandywine Township Code to develop the property located at 1163 Horseshoe Pike, Chester County. 30/5/323 with a 15-lot multifamily dwelling development under the TND1 Traditional Neighborhood Design District requirements. The applicant also requests a modification to the requirements in section 399-41.b, section 9, to extent necessary to pursuant to the authority in section 399/137.c, section 7 of the code. Tonight is the hearing date, March 15, 2018 at 7:05 p.m. And I'm going to turn this over to Kristen Camp, the Township Solicitor, for the board exhibits.
Thank you. So I'd like to introduce board exhibits first. Board 1 is the conditional use application. This was dated June 16, 2017. With the application came a conditional use plan. It was titled Proposed Townhouse Development, prepared by D.L. Howe and Associates, dated June 14, 2017. Board Exhibit 2 is correspondence dated July 28, 2017, from applicant's counsel, Allison Zaro, granting an extension of time to hold the hearing until September 30th. When a conditional use application is filed, the state law says that the board has to hold a hearing within 60 days. And so that letter was sent to be able to extend that time frame. The next three exhibits are also similar letters. Board Exhibit 3, correspondence of September 15th, 2017, from applicant's counsel agreeing again to extend the time to hold the hearing. The fourth exhibit, correspondence dated October 27th, 2017, from applicant's counsel agreeing to continue the hearing. And then the last one, B5, is correspondence dated January 24th, 2018, from Ms. Zaro granting extension of time to hold the hearing through March 31st, 2018. And part of the reason why the applicant kept continuing for the board to hold the hearing was because they had to go to the zoning hearing board and obtain various special exception and variance relief for part of their project, which I'll explain in a minute. So they wanted to go through that hearing process before they came to the board on the conditional use that's before them tonight. Board Exhibit 6, tonight's hearing was advertised in the Daily Local News on March 1st and March 8th, 2018. Board Exhibit 7 is a list of property owners who received notice of the public hearing, and I believe that's within a 1,000-foot radius of the property. Board Exhibit 8 is an affidavit of posting. This particular property was posted on March 1st, 2018, and I have an affidavit confirming that with photographs. Board Exhibit 9 is correspondence dated July 6, 2017, from the Township's traffic engineer. His name is Andres Heinreich. And Board Exhibit 10 is correspondence dated July 7th, 2017, from the Township civil engineering firm, Pannoni & Associates. Specifically, that letter was authored by Nathan Klein. That's Board Exhibit 10. Board Exhibit 11 is the Planning Commission reviewed this application, both for the zoning hearing application as well as this application, and I have their meeting minutes from July 12th, 2017 and August 2nd, 2017. Those will collectively be marked as Board Exhibit 11. Board Exhibit 12 is the Historical Commission meeting minutes. The applicant attended those meetings on June 14th, July 12th, and August 9th, 2017. So all three of those meeting minutes will be marked as Board 12. Board Exhibit 13 is the Zoning Hearing Board decision. That decision is dated March 7th, 2018. And the final board exhibit for right now is Board Exhibit 14, which is email correspondence from Scott Pearsall, acting as the zoning officer. That letter was dated October 6, 2017, and that provides a zoning determination of a specific issue that was raised in the Township Engineer's review letter. So as I referenced, the applicant had to go to the zoning hearing board. That is a separate legal entity. The members of the zoning hearing board are appointed by the Board of Supervisors, but they are a quasi-judicial agency who has specific jurisdiction that's outlined in the zoning code. And the applicant, in order to construct this 15 townhome development, needed to disturb areas of steep slopes. They needed variances from some of the regulations relating to the use within areas of steep slopes. The zoning hearing board conducted a hearing on February 6, 2018, and the decision that the board rendered, as I said, was marked Board Exhibit 13. That dealt specifically with disturbance and uses within areas of steep slopes. Tonight's hearing is the actual use. So the zoning ordinance can define what various uses are allowed, either as by right uses, which is something that the zoning officer can issue permits for. They have what's called special exception uses, which can only be approved through the zoning hearing board process. And then they have what's called a conditional use, which again is the Board of Supervisors is the only entity that is authorized to grant conditional uses, and they have to do so following the state law rules, which means they have to have a public hearing. And they have to have that hearing be advertised, the property has to be posted, we have to hold the hearing within a certain number of days, and at the conclusion of the hearing, the board has 45 days to render a written decision, and that decision has to be done at a public meeting. Part of this process does allow property owners who own property or lease property in close proximity to the applicant's property. You have the opportunity to request to become a party to the hearing. And to be a party to the hearing means that you can present whatever evidence you'd like to present. You can call experts, you can bring in traffic experts, or whoever you'd like to present, or you could just yourself testify. You also have the opportunity as a party to cross-examine the applicant's witnesses. If you don't own property within close proximity, and there's no bright line rule what that means, there's case law that says 0.8 of a mile is too far away from the property to be granted standing, but 500 feet, 1,000 feet, that is within close enough proximity to be granted. And that's something that what I'm going to do is ask that anybody that requests to be a party to come forward. We'll take a minute, we'll go off the record. If you can complete this form in legible handwriting, because I really need to be able to read your name and your email address. And then we'll go back on the record and have the applicant's counsel hear who's asking for party status. They can make objections, and then the board ultimately will make that decision. If you don't own property within close enough proximity, then you still have the opportunity to participate. This is a public hearing. So you'll still be given an opportunity to ask questions. You can make general statements and comments at the end. The most important key part about being a party is that you have an opportunity to appeal the board's decision. So if you are dissatisfied with whatever decision the board renders, if you're a party, you'll have 30 days to appeal that decision to the Court of Common Pleas of Chester County. If you don't know if you want to be a party, but you think, I'm concerned about this, you need to request party status here. You can't do it after the decision's already rendered. So is there anybody that has any questions specifically on what tonight's hearing's about and what your legal rights are as members of the public? Or any of the board members have any questions about the process?
Well, I'll allow, if we can start with the audience, because obviously they're here for a reason, so.
Okay.
I think
Anybody have
that's-
questions? And also, most importantly, this nice woman here is the court reporter, and she has to take down everything everybody says. So one person has to speak at a time. If you can come forward and state your name, address, and speak loudly when you are called upon. Thank you.
Am I called upon?
You're called upon.
You have to raise your hand first. No,
I
I'm kidding.
object. No, Scott Brown, 102 Cherry Grove Lane, Downingtown. My question, I just wanted to confirm, you mentioned about the public notice for this hearing. Was there public notice required for the zoning hearing
So-
that happened in February, that per the email that I had sent out?
Right. Mr. Brown, I did look at the zoning ordinance, and what the zoning ordinance says, it's the same procedure for zoning hearings and conditional use hearings. And it says that upon request of the zoning hearing board, that notices will be mailed to people within, I think it's 1,000 feet. But it does say that if they're not mailed, it doesn't mean that the hearing cannot go forward. I did confirm with the manager that there was a map drawn in terms of defining the radius, and they've confirmed that there were 95 property owners within 1,000 square feet that were mailed the notice. So that came from, was it Noran that confirmed that?
Lisa Tarashi.
So they did confirm that that was done.
Excuse me.
So,
So if a large number of those houses within immediate proximity never got said mailing, and it was admitted that a public notice was, the ball was dropped, and that actual notice via the paper or the website was never posted, we're just out of luck, I guess, that a handful of us never got said notice.
yeah, I mean, again, the state law doesn't require it. The township ordinance says it's not mandatory, although it's something they try to do, and I think they attempted to do that.
So can I ask the board to consider something or move to consider something? Am I, as a resident? Could we consider another zoning hearing with the public, those people who were directly affected and never got notice of that
Yeah.
hearing back in February?
Right.
Our
So-
request is to have another hearing so that people within the township and the residents immediately impacted can voice their concerns prior to a process of transparency continuing. So kind of backing up and starting.
Right, but we would not be able to do that, because now the applicant has granted legal rights that does follow the state law. That's not to say that the public that's here tonight, or anyone else that, again, would meet the standing requirement, has the opportunity to voice their concerns on this particular application.
Understood.
So that was one piece of the puzzle, so to speak. So absolutely, you have the right to participate in this process and to let this board know what your comments and concerns are.
And Kristen, he actually brought up a valid point, because I did get your email last night, and I forwarded it to Kristen. The other thought that I had, and this is totally up to Rouse Chamberlin, but there might be a feasibility of being able to bring up your concerns regarding that zoning hearing that you didn't get to voice, and see if there's any concessions that they would be willing to make.
I think we would do that tonight. I think we have a list prepared specifically.
And then
for
let,
that.
you know, if there's no legal way that we can go backwards, at least maybe there's something that they could tweak.
Understood. All right. Thank you. for
Sure.
your time. And you'll
Right.
announce when we want to sign up.
So at this point in time, if we're going to go off the record, if there's anybody that's
Well,
seeking.
does anybody else want to comment besides Mr. Brown?
Vic Barrett, 116 Cherry Grove Drive, to come up.
Yes.
Yeah, if you didn't mind, just because
Usually my voice carries enough.
if these ugly mugs have to be on camera, so do you.
No worries. Vic Barrett, 116 Cherry Grove Lane, Downingtown, Pennsylvania. So in reference to what Scott said, the 95 mailings that were sent out, how many, I know I didn't receive it, so do we have confirmation of at least a large percent of those 95 actually got the mailing? Because to say something got mailed,
Sir, I have a list here of who was supposed to be getting the notices, so that's all I can tell
there's no
you.
validation of it.
And as I said before,
It's an honor
they're
system.
doing the best they can. This was certified that this was sent. It is not a requirement under the state law, or the township code for that matter, although they do endeavor to try to get notice. And again, luckily, there is another hearing process that you're now able to be a part of.
Okay, thank you.
Sure. Any other questions on process? Okay, so why don't we go off the record? Everybody who wants to be a party, come forward, grab one of these. We have some pens you can use. Please write legibly. blackrock.com. Okay, so let's go back on the record. So what I'm going to do is identify the requested party's name. Ms. Zaro, I'll tell her where you're approximating your property to be, and she can voice an objection or not. If she does object, we can take it under advisement, or the board can make a decision. Joseph Markowski at 106 Cherry Grove Lane, and he indicates his proximity is 30 feet. Is there any objection? No objection. Okay. And I will send you their names for their spelling. Sure.
I just want to confirm as each one goes through that each of these are landowners in the township, because that would also affect my position on standing.
Okay. So is everybody who gave me a paper own the property that they listed? Okay. Thank you. Michael Lembo at 109 Cherry Grove Lane indicates its proximity is 100 yards.
100 yards. I guess it'd be easier if there was a map to understand exactly where these are. It sounds like they're Hopewell residents, but the question is, are they right there? Are they down the street? Across the street? That might be an easier way to estimate it.
Hey, Luke,
I'm seeing if we have him on this
Okay.
list.
can you blow up the camera here?
Yeah, she wants to continue it anyway.
Might be easier to do it that way. They just can point out their property
Just
now.
getting the parties in.
I would just suggest
Yeah. Okay.
you just,
So they're the parcels.
Allison, why don't we, if we
Yeah.
want, why don't we do this? Why don't we just name them all,
Yep.
reserve your right to
Yes.
object at a future time based on looking at a tax map?
I think that would be helpful.
Okay,
Thank you.
so that's what we'll do. So the next one is Dave Graf, 26, I'm not gonna pronounce this right, Wellesley Lane.
that's perfect.
Okay, and it's within 500 yards. Scott Pauls, 108 Cherry Grove Lane. Says 0 feet, so I don't know what that means, how close that is. Is it the, he adjoins the property, so adjoining property. Scott Brown at 102 Cherry Grove Lane, within 500 feet behind, adjacent to the rear. Okay, Jason Warner at 112 Cherry Grove Lane, says approximately 200 feet. Timothy Breslin, quarter of a mile, his address is 36 Wesley Lane. Martin, I think it's Martin, Vico, proximity, 200 Montpelier Drive, and proximity 1,000 feet. Victor Barra, 116 Cherry Grove Lane, within 1,000 feet. Ken, I think it's Ken, Grossmar, 24 Wesley Lane, within 500 feet. Jobin Pathapilli, close enough, at 25 Wesley Lane, within 500 feet. Mark McLaughlin, 207 Montpelier Drive, behind the property. And John, I think it's Winters, 555 Reeds Road, at Bondsville Road and East Reeseville Road, quarter mile. Okay. So, those are the people that are requesting party status. I think what we'll do is we'll give the applicant's counsel a chance to look on a tax map, and at a future hearing, she can come back, and if she has any objection, or she can even let us know through correspondence back to the board, and I will let the parties know if she voices objections, so you can be prepared at the next meeting. Ms. Zara, you had indicated that if there were going to be a lot of parties, that you were going to ask for the board the ability to continue the hearing, so that your client, I think, wanted an opportunity to try to meet with the residents. Is that still what you're hoping to do?
Yes, that's correct. Also understanding that the board has a regular meeting tonight, and I think that this is going to take a while. I think it would
I
be more
bet you everybody walks
expeditious.
out of here right after you're done.
I think it would be more efficient for everyone if we continue tonight, give us an opportunity to meet with the residents. We've been at this process for about a year now, but it sounds like a lot of people are just finding out about it tonight. And I think Mr. Penders would like the opportunity to discuss with them. So we would like to request a continuance on the record, if everyone's able to pick a date certain, if that works.
Well, was it something you guys wanted to do on your own first and then bring us into this, or is it something you
Yeah.
wanted?
Yeah, we would request a continuance. We would go meet with them, try to address their concerns, and then come back for a future
So,
hearing date.
who would be the point person, Scott? Okay, so let's make maybe the two of you guys the point people, we'll say, just in case somebody's traveling for work. And,
We'd like to go off the record and pick a date if we can.
well, what my thought was, if they could have their private meeting first, and then we can have our public meeting.
But you have to re-notice.
The voice.
If we announce a specific date tonight, then we don't have to go through the re-advertisement.
Okay.
And then if they're not ready at that time that we pick, we can continue it on the record again.
But you
Well, I
just-
wasn't even considering it on the record. I was considering it like,
Gives us like $1,500
Yeah.
to re-advertise. So, do you guys want to do it at, I would suggest you do it as a separate night if you can.
So let me-
Or start a lot
all
earlier.
right, so they cannot meet in person together without,
They can meet.
that's what I'm talking,
Yeah,
that's what I'm talking about.
absolutely.
I'm-
Oh, yeah,
I'm
they'll
saying
meet.
let them meet
how
ahead
long
of
is it
time,
take you
and
to
then
get
we schedule our
Well, I
meeting.
would say at least go 30 days out,
Yeah,
right?
Yeah,
Like go 30 days out.
because if they can
Yeah.
hammer out a lot of their questions, it will be a shorter
like
meeting
2
for us.
weeks. Are you generally available on Wednesdays?
3 weeks,
3 weeks?
Thursdays.
Thursdays. Oh, okay.
Yeah, Wednesdays are good.
Do you want this?
3 weeks.
I mean,
Let's do a month out.
do you want to just do the next,
I can send it to
before
you
the next
electronically,
supervisor meeting? That
too.
way they can meet between
Well, I can-
now and
Is
then.
that enough?
Because we're gonna go through here, and this is gonna be, I think we have to do this one night where it's just this.
Yeah, it's better to do it just on a separate night, because then all these people want to speak, that's going to be a couple hours.
May 2nd night.
Refuse and recycle.
The second works for me.
May 2nd?
And what is that day?
It's a Wednesday. I was
first-
trying to.
Yeah.
That works
Is
for
that
me.
an evening time you're
Yeah.
thinking?
Yeah,
How early do you guys want to start? You want to do 7?
well, if we start at 7, you got
7, yeah.
3 hours.
3 hours, yeah. May 2nd? It's the first Wednesday of May.
You're on vacation that
You're on
week?
vacation. She goes on more vacation than anyone I know. I'm kidding. She doesn't have any kids.
9th?
That's fine, works too.
I'm sure Mother's Day's got to be in there someplace.
Mother's Day's that weekend. Mother's Day's that weekend.
It's not
the
a
12th.
Wednesday. It's never a Wednesday.
No,
No,
we're off the
no.
We're just trying to hammer out a date that we can have our hearing, and then,
Work for you?
be- well, the thought process that I had at least was let you guys sit down together outside of the township, get your questions answered that you have, try and hammer out any details that you can, so that the problem is a hearing, if you were to do, they're not ready for a hearing tonight first, but second of all, if we were to have a hearing tonight, it would be probably the better part of 4 hours with this supervisor meeting as well.
No, they're
They're
prepared.
prepared for
They're
a meeting, but
prepared,
not for all your guys at once to have questions and answers.
Ours are more towards the actual conditional use at this point, for the township, not for them.
Right, I think, but it's not uncommon for a developer to want, without having the board involved, to try to meet and hear the concerns, and to the extent that they can address any of your concerns, make tweaks to the plan. If that can't happen, that's fine. You're gonna come back and we'll have the hearing, and they'll know, and they'll also know who is a party and who's not a party, because they'll have an opportunity to look at a tax map and know how far away the requested parties live. So I think that's, the other thing is, we really don't want to be scheduling the hearings right up against a regular board meeting, so we're going to dedicate a night, and that's the only thing that's going to happen. And if we have to stay here for 3 or 4 hours, then we'll do that. So May 9th is a date that the board is considering. Are the parties generally available on May 9th? So that happens, this happens very frequently, that these conditional use hearings sometimes can go on for a year, that they often get continued for various reasons. It's not an unusual process. So the applicant needs an opportunity to see a map and see where everybody lives and determine whether they have the opportunity to object to your standing. You're not automatically granted standing. You do have to show that you own property within fairly close proximity and that you would be aggrieved by a decision of the board. So I don't want to just not give them the opportunity to be able to analyze where everybody lives and make the appropriate objection or not object for that matter. And again, I think it behooves everybody to let, if there's concerns and issues, deal directly with the developer. Try to get that hammered out with them. And then, if you can't, then obviously you have the right to come back to the board and voice your issues and concerns. Okay? So May 9th, does that generally work for the parties? Okay, Mrs. Art?
Yes, it
Ms. Art,
does.
does that work for the applicant?
Yes, it does.
And we will start, is the board comfortable with starting at 7 PM on May 9th?
Yes, and then we'll have the 2-point people, Paul and Scott, in touch with Allison, and then you guys can set up your meeting ahead of time and hammer out the details. Remember what I said, if there was issues with the zoning, if there was issues with the supervisors meeting that was prior, the planning mission, if you have issues and questions with that, maybe there's something that can be adjusted on that end, and it's not just this end.
Is there going to be a firm no continuance after May 9th?
We can't do that. The applicant has the right to request continuances. I mean, we're anticipating that the board will go forward on May 9th, and I think that's what the board's druthers are. So, but we have your communication, your email now. What I'm going to do is all of these board exhibits, I have a couple extra copies if you prefer paper copies, but I also can email everybody who's requested party status all of these exhibits, which I think will be helpful in your review of the application. Okay? Does anyone else have a question before we close this hearing? Sir, can you state your name again?
My question is that for all those who could not attend this meeting, what is the process to gain standing?
Great question. They're able to come on May 9th, and they're able to request party status.
Request, but then it has to be granted thereafter.
At anybody who requests party status, we have to give the applicant the opportunity to object, and then it becomes a legal ruling of the board. So again, I will tell you that if they receive notice of the hearing, then there's pretty much been a legislative determination that that's close enough for you to be granted party standing.
Right, but is there a process in the interim to gain standing so that?
No, that you have to do it at a public hearing. Everything that's taking place is being transcribed, so that if somebody files an appeal, the court has exactly what happened at this proceeding.
Thank you.
Thank you. Any other questions?
One last one.
Go ahead.
If there are conditions that we were requesting of the board that aren't addressed with Rouse Chamberlin, because we don't feel that they should be addressed with them, but the board and the township, do they have to be addressed with them?
No,
You
absolutely
have
not. You
your-
can
you
bring
have
it to the
your-
board.
You have your same opportunity to speak at May 9th with your concerns.
Correct. Okay, well, we appreciate people coming out tonight. We appreciate your involvement, and we hope that you guys can have a good meeting, and we'll see you on May 9th at 7 PM. The board's regular meeting will commence as soon as, if people want to take time to clear the room, that's fine. Again, I have a couple paper copies you're welcome to take, and otherwise I'll email you. Sure.